Good afternoon, everybody. And I'd just like to call this meeting to order. We do the land acknowledgement. Oh, am I to do the land acknowledgement, Kathy? Okay.
We would like to acknowledge
that we are here today
on the traditional territory
of the Mississaugas of the Credit First Nation.
Nous tenons à reconnaître que nous sommes sur le territoire traditionnel
des Mississaugas de la Première Nation de Credit.
Thank you. Trustee Andrews, can I ask you to move the approval of the agenda?
Absolutely, I will. Thank you.
Great. Thank you. So hearing no objections, are there any declaration of conflict of interest? No. Okay, hearing none. Trustee Crocker, could I ask you to move the minutes of the meeting of June 15th, 2022?
Yes.
Thank you. So at this time, I'd ask if we could have the staff report 6.1, please.
Thank you, and through you, Madam Chair. As you may recall, we had the first discussion around the policy management program, a program that will provide for a coordinated approach to develop consistent, comprehensive, and compliant policies at the June committee meeting. One of the first steps in establishing a policy program is to establish a foundational policy. I will now call upon LaShawn Murray, our policy analyst, who will take us through the policy development and review framework for which we are seeking this committee's recommendation to the board for approval. LaShawn?
Thank you, Catherine, through you, Madam Chair. So as Catherine mentioned at the June meeting, June governance and policy meeting, we brought an update on the development of the board's policy management program. And the overall goals for the program is to develop and implement a framework for a systemic approach to the development, review, approval, and repeal of policies, to establish naming and numbering conventions for all policies and procedures that reflect their purpose and function, to identify and address any gaps in both policies and procedures, and to ensure that all procedures are updated and ladder up to a parent policy. And so attached, we have the policy development and review framework, which is a foundational element for the upcoming policy management program. And it sets out a transparent and consistent approach to the way in which we develop, review, amend, approve, and repeal policies within the PDSB. And through this framework, we hope to ensure that all policies are compliant with relevant legislation and align with the board's vision, goals, and priorities. It ensures that all policies developed and reviewed are accessible with respect to language and availability, that we apply an anti-oppression, human rights, equity, anti-racist approach to the ways in which we develop and review policies, and we engage the community wherever applicable. Within the framework, it also outlines the roles and responsibilities of relevant stakeholders, including the board and within leadership within the PDSB as it relates to policy development and review. And since our last meeting, there's been one minor change between the framework that we presented in June, which is the reference to executive council. In this upcoming school year, the executive council structure has been replaced by directors council. And so we made that amendment within the framework. Next steps within the department is to finalize a design template to accompany the policies. This is a look and feel of the ways policies are presented, to finalize the naming and numbering conventions. The framework references a periodic review schedule, so we'll be working on that over the coming months, and to develop related procedures, which includes establishing a process for the approval of procedures within the board. Thank you.
Your microphone is off.
Sorry, thank you for that. Are there any questions? Thank you, LaShawn. And I was just wondering if there were any questions from any of the trustees with regards to this report. Okay, seeing none, I would like to move on to 6.2, Trustee Family Leave Policy.
Trustee McDonald, could we have a motion from the committee with a mover and a seconder to recommend approval of the draft to the board at the next board meeting, please?
Yes, thank you. Sorry for that. So I would like to ask for a mover, please, first.
I will.
Thank you, Trustee Andrews. And the seconder? So would that have to be David Green because, or can any other trustee? It has to be somebody on the committee?
Must be someone on the committee.
Okay. Oh, well, he is, so I'll ask Trustee Crocker if he could second it, please.
Is he on mute?
All right.
Okay, thank you for that. So at this point, we'd like to move on to 6.2, Trustee Family Leave Policy.
Thank you, and through you, Madam Chair. The Education Act mandates that boards adopt and maintain policies regarding pregnancy leave and parental leave for members of the Board of Trustees. Historically, PDSB has not had such a policy specifically for trustees. Attached to the report is a draft copy of a policy. Passing such a policy is required for legislative compliance. By way of context, the Education Act specifies the conditions whereby a member of the Board of Trustees vacates their seat, which includes an absence of more than 3 consecutive board meetings without authorization by a board resolution. Section 228 of the Education Act outlines an exception whereby a vacancy does not occur if the trustee's absence is a result of the trustee's pregnancy, the birth of the trustee's child, or the adoption of a child by the trustee. Trustees are entitled to take a leave of absence from their duties for up to 20 consecutive weeks if the leave is a result of the trustee's pregnancy, the birth of the trustee's child, or the adoption of a child by the trustee. This leave does not require approval or authorization by the board. This establishes that there is no vacancy created by missing more than 3 meetings due to a family leave. The draft policy is in line with the legislation and with other school boards' policies on family leave. Happy to answer any questions.
Okay, thank you for that report, Catherine. And I see Trustee Lawton has a question. You're on mute too, Sue.
Sorry, I've gone like 2 months without doing that. Can I ask if that extends past parents, so grandparents? Is that possible? Is it?
It does not. It is meant for parents, not for grandparents.
Okay. So if I may ask this follow-up, so if there's a particular difficulty that with a child's baby's birth or a child's sickness, is there some kind of leave that is possible for trustees, a family leave, or not at all, with the exception?
Through you, Madam Chair, there is always the possibility of a trustee asking for permission from the board to miss more than 3 consecutive meetings. And then the board is at liberty to pass a resolution permitting that. The issue is by missing three meetings, consecutive meetings without permission, the seat is deemed to be vacant. To avoid the vacancy, a board resolution can be passed with granting permission to be waived for more than 3 consecutive meetings. The trustees are not employees, so family leave provisions under the Employment Standards Act, etc., do not apply to trustees. So the only real mechanism to give the trustees family benefits is through this policy, which is provided for under the Education Act, and we're required to have to be compliant, or the alternative is a trustee resolution permitting the absence for more than 3 months.
Okay, thank you. Certainly have used that in the past, so I know that that's available. So thank you very much.
Thank you.
And I saw Trustee Davies' hand up.
I listened very closely to Catherine and she answered my question, your explanation. Thank you.
Okay, great. Are there any other questions from any other trustees? No? Okay, thank you so much for that, Catherine. And I'm going to ask Trustee Crocker if he would move 6.2, please.
Sure.
Thank you. And Trustee Andrews, would you second it?
Yes, I will.
Great, thank you for that. So we're going to move on to 6.3, naming and renaming of schools, special function areas, and facilities policies. So, Catherine.
Thank you. And through you, Madam Chair, the existing policy 27, naming of schools, was in need of updating and revising. And as such, a working group was struck to conduct an equity review of the policy and report back with recommendations. I'd like to call upon Superintendent Donna Ford, whom you are all familiar with due to her great work in equity, to review the recommended policy updates.
Thank you so much. Good afternoon, everyone. And through you, Chair, Directive 18 requires the board to undertake a comprehensive diversity audit, which includes, as you were probably familiar, the naming of schools, as well as names attached to mascots, libraries, and classrooms. This update, as you are aware, pertains to the naming of schools, and the directive was the impetus of the review for Policy 27. The review has been undertaken through Directive 18 by a working group to expand on the earlier writing of the policy. The review and update of the naming of schools policy seeks to do these things: provide a framework that includes the naming of schools as well as special function areas and facilities. It suggests a process for the naming of these spaces, ensures that consultation is integral to the naming process via a committee of diverse members, ensures that the carriage of anti-racist, anti-oppressive, and anti-colonial a stance in the decision-making through the perspectives brought by the committee members via their unique lived experiences, and finally, ensures that trustees are essential to the approval process. Directive 18 has guided the renaming process, as you know, through the renaming of Nibi Emo Sadung Middle School last spring. And while that process didn't specifically engage the policy, it did provide an example of the demonstration of community engagement to which the revised policy gestures. Both internally and two of the committee members here today were a part of that process, and through the engagement of our external stakeholders as well. The importance of community engagement also reinforces the idea of the deep meaning of school names to the local community, and how those names represent the PDSB commitment to anti-racism, anti-oppression, and anti-colonialism. It is our hope that this policy provides a way of understanding those key ideas going forward in anticipation of future renaming or naming as they may arise. Happy to take questions.
Thank you, Superintendent Ford. Does anybody have any questions for Superintendent Ford?
I have a question.
Yes, Trustee Crocker, you can go ahead.
So I've been asked by people, a friend of mine is a member of the Indigenous community, and this was in the context of the renaming of the school on Center Street in Brampton. Why do we name schools after people anyway? I've used this example before. 40 years ago, if you'd named a school after Bill Cosby, that would have seemed very progressive. And it wouldn't look so progressive today. In fact, the name would have been changed.
Mhm.
And we can't foresee how this is going to run in the future. But there are so many irregularities in our naming system which could be easily avoided. If instead of being named after Sir John A. Macdonald, if it had been called Center Street School, that would have worked just fine. I have a lot of schools in my area that are named after the street. McBride Avenue Public School. It's on McBride Avenue. Streetsville Secondary is in Streetsville. Clarkson Secondary is in Clarkson. And they know that that's what police and fire department really like. Hillside Public School is on Kelly Drive. There's a Hillside Drive in Streetsville. It doesn't have a school on it. That's confusing. The hill that Hillside's on isn't even much of a hill. So, I mean, it's not like a local landmark or anything, you know. It's not like the White Cliffs of Dover Elementary School, where it would be pretty obvious. So I would really like us to go back to, and I hope that the future board revisits this and takes a look at the police and fire department protocol and sticks to local names. I know that it's not always possible. We have a secondary school, I believe, on a street that's named after a religious figure for, I think, a Catholic bishop, archbishop. And obviously that doesn't work. But anyway, there's the objection. Please stop naming schools after people, period. Thanks.
Thank you, Trustee Crocker. Are there any other questions? No, well, I have a question. Under 5.1, the second, no, I think the last sentence, it says the family of school superintendent, in consultation with their associate director, approves the naming or renaming of a facility or special function area. And I have concerns about that because I think this could be done privately, right? Mm-hmm. And I think something such as naming of schools, facilities, special function areas, I think it should be a public process. I think the public should have input in it because, you will have different directors, different associate directors. And, in the past, a lot of schools have been given out as trophies. People would make the comment, why are we naming after a school after someone who we pay a lot of money to do a job and they haven't really done or gone above and beyond their job description. So in the past, just by virtue of the fact that you're a director, a school was named after you. It didn't matter if you were brilliant or you performed poorly, right? So I think that it's important, in my opinion, that we don't have processes that can be done in private. And, it's a slippery slope. And I still think that it's a way, let's say somebody names a school after, a beloved staff member that they deemed beloved. Somebody else might come up and say, hey, because it wasn't a public process, but that person harmed me or this person did that. And I think when we're naming facilities, it really should be a public process. So I just wanted to note and register my objection to that part of the policy.
May I respond?
Sure.
Okay, thank you so much for your remarks, and through you, Chair, everything that you've expressed came up in our committee discussions, so thank you for raising them in this forum. Number two, what we were trying to attend to were two things. One, the set of procedures that are not yet written to make sure that the steps attend to the naming of a facility or a special function seemed to be in the mind of the committee of a smaller scope or a different scope than the naming of school. So to capture some of what you have raised here, Trustee McDonald, still we would be engaging local community, structures such as school council, local parent advisories to be able to weigh into some of what what we would care to avoid. So these are things that we're thinking about in terms of the procedures specifically that are not yet written. That said, your remarks are noted, and I would like to take those forward into the writing of our procedures.
Thank you. Because you see, in the policy, there's nothing stated explicitly
Correct.
that community will be involved.
Yeah.
So that's why I have an issue. Like I couldn't accept the policy as it. Like I wouldn't vote in favor of this policy because I think it's critical that public input be given for any such activity before it's passed, right?
Very good.
So yeah, thank you. Trustee Crocker?
So I have a housekeeping concern. I don't know whether this is for Donna or for Catherine, and I believe it's on page 3 of the report. Third bullet, third sub-bullet, if that's the right term, where it talks about replacement. So it says replacement, i.e. replacing an elementary school with a secondary school. i.e. is restrictive.
Yes.
It means that is, and I think what you want there is for example.
E.g.
I can only think of one example in the past. Morningstar used to be a secondary school, and it's now a middle school. So that one would have run contrary. So just change it. Is my suggestion to e.g. or for example.
Very good. Thank you so much.
Thank you.
And if I may, I just also I didn't see where in that in this where the trustee voice is part of this also. So I think that's critical because trustees are often the voice of reason for the community. So I think that's need to be in there. And I want to also echo the sentiments of Trustee McDonald. So in totally agreement with those comments.
Thank you, Trustee Green, and noted. I do want to make the remark, if I may, if it appears to you that section 6.1, it said Board of Trustees approve the proposed name or rename by a school by a majority of the vote. Does that still seem incomplete from your perspective in terms of the trustee role?
But I could answer that. In my opinion, I think it does, because it doesn't include us in that, the renaming of the facilities or special function areas.
Okay.
Yeah. So we have the way the policy is written, it excludes us from that part of it. So for the naming of schools, yes, but not the facilities or special function areas.
Very good.
Yeah. Trustee Davies, your hand is up. Oh, sorry, Trustee Crocker, your hand is still up. Do you have another question?
I don't.
Okay, thank you. Trustee Davies?
I just, from casual observation of the last 10 minutes or so, Trustee Crocker's suggestion that we name it after street names, schools after street names, certainly would solve a lot of arguments here. So I just wanted to sort of make that comment and throw my support behind that if possible.
Okay, thank you for that. Trustee Lawton? You're on mute. Yeah.
Twice in one meeting, I'm sorry. Superintendent Ford, can you tell me why we wouldn't include this being public in the policy? A public process?
Can you tell me what you mean by a public process? My apologies.
No, that's okay. I'm referring to Trustee McDonald's comment about and Trustee Crocker and Trustee Green about the fact that it would not be something that was done in private.
I think that from what I'm hearing, it seems to me that those are pieces that need to be in my understanding, the procedures where we're being specific in terms of the steps, who's involved, the stakeholder involvement. This is what I'm surmising from the remarks that are being made. I think the policy simply, outlines the intent. If there's a place, and I've made some notes here where that can be clarified, happy to go back and look at that. It's not. I'm hearing the importance of making sure A, that trustees are involved, and B, that engagement is, in front and open and transparent, not behind closed doors, which is what the rewrite was intended to address. If in our language we can that can be clarified, happy to go back and to look at that.
Thank you. I appreciate that.
It's a
so. Sorry, Trustee Norton.
No, that's okay. I was just going to say I understand that there are often things that are not included in the policy. They're in the operating procedure. That's a tough thing to have to say in front of a group of people who are asking the question in a boardroom setting or anywhere else. You say, we'll go and look at the operating procedure. That's not always the most effective way to deal with a public question like that. Thank you.
And thank you. And see no further questions. I just want to ask you, Catherine, so it's here for approval. So I could get somebody to put it on the floor. Then we can vote not to approve it if we wish. Is that correct? Because it's not receipt.
You could vote for it to just be received and request that it come back. You can request it to come back directly to the board or to this committee for further review.
Okay. So first I could ask somebody to put it on the floor. Trustee Lawton would like to put it on the floor, please.
I don't make quorum, Trustee McDonald.
Oh, sorry, yeah, Trustee Andrews. Sorry about that. Would you put it on the floor, please? You're on mute.
Just following Sue's pattern. Yes, I will put it on the floor, but we're not approving as is, correct?
Correct.
Okay, yeah.
So now I guess the question is, do we want to say we're not approving it to come back to this committee, or do we want to not approve it and let it go back to the board? What? Yes, Trustee Andrews?
So I guess just clarification. So to me, it would make sense to come back to this committee before it goes to the board. So that's kind of what I'm proposing.
Okay. So then all in favor of letting, first of all, approving it. Anybody would like to approve the report as it stands? Okay, seeing none. So the decision would be to ask that this report come back to this committee with the taking into consideration the comments that you heard today, right? Okay, great. Thank you very much. And we need a seconder for that. Trustee Crocker, would you second that, please?
So I'm seconding agreement to what Trustee Andrews has said.
Right. Thank you.
That I will do, yes.
Okay, thank you. Moving along for 6.4, Trustee Code of Conduct. Catherine?
Thank you. And through you, Madam Chair, I'd like to start off with an apology. I am really sorry that you all received the draft code of conduct so late. The draft code was started almost a year ago, but was put on hold because the province had indicated that they would be doing some work and may be providing a provincial code for conduct, a code of conduct for all school boards. In fact, they sent around a survey to school boards and trustees looking for input on a provincial code. Time passed and the provincial election loomed and there was no further word, despite us following up multiple times with the ministry on what plans the province may have in relation to a code. In the future, if the ministry does provide some guidance or input, we will bring the code back to the board for consideration. Then after that, there were some changes in staff at the board, as you are aware, and after some digging, the draft code was again resurfaced. Sheila McKinnon from the law firm Shibley Wrighton, many of you will know Sheila, had been retained to assist with the drafting of the code. Sheila is a very well-known governance expert. She had an unfortunate family matter arise with her mother having a very serious car accident that put Sheila, in the position of providing extensive care for her mother and it really limited her time for work. Sheila also expresses her apologies for having the code sent to you too late. However, we were able to pull together the draft code and we did provide it to you a few weeks later than we had originally hoped. So I do apologize for the delay. The trustee code of conduct will not go to the September board, but rather will be placed on the October meeting agenda. This will provide more time for trustees to be able to review the code in more detail and provide any comments prior to the draft being presented to the board for approval at the meeting in October. And I'll be happy to receive comments from trustees at this meeting and any time before the board meeting in October. It is my opinion that this board is best situated to approve the trustee code of conduct before the start of the next term. This would mean that the new board would have an updated code in place. It is best practice, and frankly, it's also legislated, to review the code every term of office, so the next board will have a chance to live with the code and then provide any recommendations for updates, amendments, or changes during their term of office. With that said, again, my apologies for the late circulation of the draft. But I will take a few minutes here to walk through a few of the highlights, and I'll be happy to take questions today and anytime again as we prepare for the October board meeting scheduled for October 19th, which will be the last board meeting of this current term of office. So by way of context, in April 2018, Ontario Regulation 246.18 was passed, requiring every school board to have a code of conduct for trustees and for it to be in place before May 2023 and review it at least every 4 years. A trustee code of conduct establishes governing principles and standards for acceptable and respectful behaviors and provides a framework for professional conduct and responsibilities. A code demonstrates how trustees have determined to regulate themselves. In developing the draft code, we took very seriously the comments that have been made by trustees around not reinventing the wheel and to look at what others have done. The Ontario Public School Boards Association has created a trustee code of conduct template, and we did use that as a guide in drafting the code. The draft code has been prepared by Sheila in consultation with Laurie Barnes, who many of you will recall was the provincially appointed parliamentarian originally responsible for Directive 5 of the ministry directives dealing with governance, and in consultation with the Integrity Commissioner, and I also provided comments as well. The draft code addresses principles of integrity and dignity of the office, respect for confidentiality, upholding decisions, supply chain ethics, gifts, benefit, and hospitality, use of board property, services, and other resources, improper use of influence, conduct regarding current and prospective employment, discreditable conduct, reprisals and obstruction, and acting on the advice of the Integrity Commissioner. The code consists of 3 parts: the actual principles and directions, the complaint protocol, and the method of retaining the Integrity Commissioner. The complaint protocol provides for the use of an informal procedure first, as the code contemplates remediation that may positively correct inappropriate behavior. The formal complaint process is to be used for more egregious or repetitive behaviors that disrupt the ability of the board to conduct business. The code is for use by trustees and is not a code accessible by staff or the community at this time. The code provides that an alleged breach is brought to the attention of the board, and then the Integrity Commissioner shall make inquiries into the matter. The Integrity Commissioner shall report to the board with a recommendation, and then the board will determine whether a member has breached the code. The Integrity Commissioner will report annually to the board on their activities around the code. I also want to advise the committee that I heard from Trustee Brad McDonald earlier today about the code. He was unable to attend this meeting, but sent along some preliminary comments. He was concerned with the timeliness of receiving the draft code, and I have apologized to him via return email. I will review some of his comments and my responses to the comments. His first comment was around an election email in section 6.38. He indicated that he checked the couple of other codes of conduct, and they do not make reference to using contacts, emails, etc. from your work as a trustee in the election. The only reference he found was that TDSB does use that method that we have set out in the code of conduct. He does not support that and doesn't believe that OPSPA would either, since it's not part of their original template. My response was that with respect to section 6.38, it is consistent with the use of board resources policy that was approved earlier this year. The theory is that email addresses accumulated as part of the duties of a trustee are a database which should not be used by a candidate. The email addresses were accumulated for the purposes of discharging the duties of a trustee and not for campaigning purposes. Use of data collected for use as a trustee in a campaign provides an unfair advantage to an incumbent. Having said that, it's open for the committee to further discuss. Trustee McDonald's second comment was around the social media section in section 6.43. It does talk briefly about social media, but
excuse me, Kathy, could you just say Trustee Brad McDonald so that people
sorry, yes.
Yeah.
My apologies, Brad McDonald.
Yeah.
He thinks that the social media section should be more explicit and thinks that a trustee should air complaints properly through the IC, the Integrity Commissioner, and not in media or social media. And by doing, if they're airing complaints, that should be a code violation. My response to Trustee Brad McDonald was that yes, social media is a significant issue that many political bodies have been wrestling with. We did pass a social media policy earlier this year, which applies to staff, and I raised this for the committee's further discussion and contemplation. Trustee Brad McDonald had two other comments around investigation timing and trustees' involvement in investigations. He wondered about expediting the timeline for investigations to 1 month, and wondered what would happen if a trustee did not want to talk to the IC about an investigation. What were the consequences? My response is that it is challenging to put too tight a timeline on an investigation because each one may be different in complexity and may require differing lengths of time. The complaint protocol does provide that final reports of the Integrity Commissioner are to be completed within 90 days. And with respect to whether the Integrity Commissioner will be able to conduct an investigation if a trustee does not wish to speak with the trustee or with the Integrity Commissioner, the complaints protocol does provide that the Integrity Commissioner will continue with the investigation and report accordingly, and that is set out in the protocol. And I'm happy to take any further questions from the committee, like I say now, or throughout the process as we lead up to the October meeting.
Thank you, Kathy. Does anybody have any questions or comments for Catherine at this time?
So, Chair, I got a couple similar. I did not realize because Brad raised these with you because I haven't been at my email all day. But I totally sort of agree with the part around the social media. I think we need to be very explicit about that because I have seen not just in our board but other boards where because there is no the wording is very vague. There's issues that we're seeing. Um, so that one I would like Catherine that you take a deeper look at. Also, the the part I understand your explanation around what I because myself I did do some research and look at a code of conduct across the boards, various different boards, and yes, I noticed that there's quite a bit of stuff that align with TDSB is in ours. But the part about the email piece there, I have some concern about that because it's the same way as a trustee. Once you're sitting, you're allowed to execute your duties while even during election time. So I kind of have some challenge with that, but I will leave that to the majority of the board to decide. But I do have some concern. Um, I'm not comfortable with that. So um, and again, and thank you for recognizing the timeline in terms of and you did apologize right out the door, which I really appreciated because I did call the supervisor and I said that, even in a time like this when it's election time and trustees are campaigning, we need time. And this not just about policy, it's about everything that we do at the board, because when you look at any governance board, we need time to look through the documentation that are provided to us so that we can ask critical questions. So it's not just about the policy piece, but anything that we do as a board, we have to make informative decision. And sometimes we're getting 5 minutes before a meeting or 10 minutes or a day or so. It's not comfortable with me. So thank you for recognizing that, and I appreciate that. So, Chair, those are my comments right now, and open that. Catherine, and thank you because I recognize that you're a very understanding in person and you're willing to work with us as a trustee, and that you will take our comments and maybe take a look and see how we can, improve a little bit around these pieces. So thank you very much. Appreciate the time.
Thank you, Trustee. Thank you, Catherine.
Thank you. May I respond just to the one point for clarification? Thank you, Trustee Green, for your comments and particularly around the social media. And we'll definitely be taking that back and happy to hear other trustee comments around that as well to help guide how that could be recrafted to be a bit more directive as opposed to general. In connection with the email use of trustees' use of email, absolutely. Trustees are trustees until they're not, which is, at the election time for sure. And you continue to act as trustee and use the databases and the resources, etc., as a trustee. What that section is saying is that you cannot use the information that you receive as a trustee in your campaign. So for example, if as a trustee, you have a list of school council chair emails for your ward, you as a candidate for the election cannot use that distribution list for campaign purposes. If you want to use it for trustee-based purposes, sure, that's not a problem. The clause is really restricting the use of it for election campaigning purposes, and that is consistent with the use of board resources policy that was passed at the April board meeting just this past April.
Thank you. Thank you. Trustee Crocker.
Yes, thank you. I find myself in agreement with Trustee Green and also with the email that I read earlier in the day from Trustee Brad McDonald. I'm not going to reiterate those words. I will, however, reiterate thanks to Catherine for her approach with all of this. And there's marks in school for doing your best under the circumstances, and that's always been the way. And you get top marks for effort, and even more marks for the integrity around the way you've dealt with the responses. I am unhappy with a number of things in this report. I'm going to give just one example, however, and that's the business of contacting people who we would expect support from based on past performance. I agree that we shouldn't use board resources for that. I'm not running, okay? So I can take a step back. So definitely nobody should get an email from robert.crocker@peelsp.com saying vote for me. However, were I running for office as a community member, which I would be, and which I did 4 years ago and 8 years ago, that wasn't as a representative of the board. It was my saying that I wanted to represent the public in wards 6 and 11 to the Peel District School Board. And I would be counting, as other candidates would for any office, on a list of old friends, acquaintances, people who we think might like us. I mean, I was counting on people who thought that I might be their old history teacher, and they might have liked me and they'd vote for me, right? So now I might be looking at people who I did actually help. They phoned me and I explained something to them, or I hooked them up with somebody at the board office, and they're grateful. I got an email just yesterday from a mother who I'd spent many hours on the phone with various things that she was unhappy about. And she just emailed me to say, everything's good. She got great service at her child's school, and she's so happy with the acting principal and all that. So why wouldn't I be able to write back to her and say, yeah, thanks, I really appreciate it. And by the way, I'm running again. So, I'd just like you to remember that on October, somebody help me, I think it's the 24th. So there's my objection. I hope I've expressed it in a positive way.
Thank you, Trustee Crocker. Are there any other, Catherine, you'd like to respond to that?
Sure. Thank you. Thank you for raising that, Trustee Crocker, and it's an excellent example. And I can assure you that all local politicians at the municipal level and school board trustees run into this, because we are at that level of direct contact with the constituents, unlike some of our provincial politicians or the federal politicians, where they are somewhat more removed from the day-to-day happenings. And there is often a switch over and using information that is carried over between trustee duties or counselor duties and the election. So this is a struggle that all municipalities and school boards have, and I certainly recognize that. And the theory, as I noted, was really about providing an unfair advantage to incumbents. And but that's certainly something that I'll take a look at and give some more thought to, and check with a series of other boards about that as well, and come back with a comments about best practices. And I will also reach out to OPSPA and see what their actual position is, because they're silent on it. And perhaps we'll get some insight from them as well.
So thank you, Catherine. And could I just point out as well, sorry, there's a funny noise. I don't think I did it. Can I just point out as well, I don't see the difference between my going, again, and I'm not a candidate in this election, going and ringing somebody's doorbell who I know because of a positive, or it could be, could be a neutral or a negative interaction in the past, right? Politics is a funny thing. They might vote for you even though you weren't any help to them. But, if I rang their doorbell, that would appear to be kosher. if I email them from a private email address to their private email address, really in the context of the 21st century, and knowing that they're, and again, I'm not a candidate, so I don't share the nerves around this, but I don't think there'll be the degree of handshaking and sort of face-to-face contact at the doors, which leaves us back to email and texting again, you know. So there it is. I'll just leave it there.
Thank you.
Thank you. Trustee Lawton?
Somebody. Wait, after Trustee Lawton, I have a comment here.
Okay, sure. No problem.
Thanks, David. I was going to just ask, you brought up the example of a list of school council chairs or a list of school council members or whatever. Would that not be different than an individual to whom you have spoken, with whom you have dealt with, you, as Trustee Crocker mentioned, have either helped or not helped? I understand, I would absolutely understand getting a list of school council emails and sending out a mass email to them when you don't know them. There are, but I'm wondering if we might look at the if there's any kind of difference that can be drawn between an individual interaction.
Thank you for the question. And from a clarification perspective, the theory again behind it is that you have access to that email because of your role as a trustee. And the person contacted you, the parent contacted you in that role. So they provided consent to you, implicit consent, to use their email to conduct business as a trustee. They didn't send it to you as a candidate. And so that consent to use their private email was not implicitly or otherwise given for you to use that as a resource. So that resource, that email is really owned, for lack of a better word, by the board, by you as a trustee doing that task. So that's the distinction. It's the same kind of distinction between knocking on a door and using the email, in that, you know, they didn't come to you. You're going to every door along the street. You don't have consent from everyone to use their email. The Election Act allows you to canvass door to door. There are restrictions on it in apartment buildings, et cetera, but that is a permitted campaign activity. But there's no consent to use a private email for campaign purposes. But again, I'll continue to look into it to see if we can put some better refinement on the issue. But that's the theory behind it.
Thank you.
Thank you for that, Catherine. And just to follow up on her, on Trustee Lawton's comment. So let's say you have helped an individual and they said to you, oh, thank you so much. When you're getting elected again, you know, I want to help campaign for you. Wouldn't that be considered,
yes,
then giving you permission to contact them if the person has said, I want to help you?
Yes, that is consent that you could, you know, record in your campaign, and then you could use their email address because you have consent to do that.
Okay, thank you. Trustee Green, and then Trustee David.
So comment I wanted to make, just so everyone know, that I was one of the trustees when the minister was doing the consultation around trustee code of conduct, was to come out with their piece. Actually, I was part of the table because there was a number of trustees across the province that actually the ministry had contacted directly to be part of that voice, to hear from trustees across the province. And I was one of those trustees that was at that table. And one of the things that came up at that table is that we were deemed to seems to be held higher in terms of when it comes to code of conduct, higher than MPs, MPPs, and city councillors. So there was a big discussion around that, and the question is why. And there was feedback that was provided to the ministry around that, and the concern around that, because we are school board trustee, which nobody really recognized much, because even in election when they have debates or whatever the case might be, trustees are not invited to those. We're at the lowest end of the spectrum. So why are we deemed to be held higher than everybody else in terms of accountability? So that was a big discussion at the table, and feedback was provided to the ministry. I know also last week, Monday, the Ontario School Board Association, the executive table, we had our planning day, planning for the year, the school year. And again, that was one of the challenge and the discussion that was part of that meeting, because we also, and Kathleen, you rightly said you can't use this, but it was brought up at that table by other trustees who said, okay, people who are running against them would already have these contacts and they're contacting these people. So my question is, if your opponent are able to contact school council chairs and so forth and ask for support, so why can't trustees who are incumbent do the same? So just my comments, and put it out there. But again, as Robert said, like your approach, that you're listening and you're taking those back. So I appreciate that. So thank you.
Thank you. And you can respond, Catherine.
Thank you. And thank you for that clarification, Trustee Green. That's very helpful. With respect to if your opponents can contact the school councils, why can't you? You can. You just have to dig for their email address, just like your opponent did, off the websites, etc. It's simply stating that you can't use existing emails that you had from your time as a trustee, and in your database, in your contacts or whatever, you have to go through the process same way your opponents did to be able to contact the school councils or whatever other mechanisms that you wanted to contact people. But a great point, great discussion. Thank you.
And thank you. And Trustee Davies?
I'm just wondering, does that apply to phone numbers as well? I mean, I know I can't use the board phone to phone the person back and say, hey, I helped you out back in 2019 or whatever it is, but we are given a list of phone numbers from the electric office. So logically, that phone number is in there. I'm just putting a name to a number. As long as I don't use the board phone number, logically, that should be okay, correct?
Again, it's how did you obtain that number? So if you're saying that you got that number from through the elections office because you have the voters list, then you acquire that information through a process that was outside of your role as a trustee, and it was inside your purview as a candidate to pursue those numbers. So if you're using, if we think about private information as we all own our own private information, we lend our private information to others sometimes for particular use. So if a constituent has lent you their personal information, their phone number, their email for a particular use, you're more than entitled to use it for that use. But extending that use requires consent. So without that consent, it's actually a board purpose for which you had it, and board resources, which includes database and private information, cannot be used in campaigning. So if you obtain that phone number, it would be treated much the same as an email address. If you received it through the City of Brampton clerk's office, and when they provided you with a voters list, then by all means you can use that. Does that make sense? Sorry.
Yes, it makes sense to me. Yes.
Thank you.
Well, thank you for that. And I see there are no other questions.
Trustee Davies is still with us.
Yes, he's there.
Yeah, I'm still here. I'm still here.
I can see him. Yeah. I have a few comments. First, I would mention what was, people have been raising. So with regards to social media, I think that when we're looking at the social media aspects too, we have to consider what is our chartered rights. For example, when in my second term, an individual from the board had instructed me I used to write for a newspaper, and I was told that I couldn't do that. It's violation of code, and I would be brought up for the code. And so I stopped writing because of the climate, and I didn't want to be like harassed with code of conduct. However, I was told by a human rights lawyer that was a violation of my human rights, that I am allowed to write for a newspaper. So I think we have to, so technically, the board had no jurisdiction or authority to prevent me from writing. So I may return to it with the new board after this election. So I think we have to, when we're making policies and giving instructions, that we don't violate people's human rights. That's just one thing I think we should note. And also the comment about a timeline. I think a timeline is important because, depending again who the IC is, a person could drag on a case for a year or 9 months, which has happened in the past, because I know you have 90 days to write the report, but technically they can drag out investigation as long as they want. And especially it can be a way of bullying and tormenting individuals too. So again, it depends on, the individual, the IC and their intent. Another thing with the IC that I didn't see, and I didn't see it in the hiring of the IC, and through this document, I didn't see, for example, which I'd like to see or consider if you would, the fact that it should be almost a grounds for termination if an IC approaches trustees and asks them, or public, and asks them to make complaints against a trustee. I think that should be an immediate termination, because I think that's unethical. And again, that has happened in different cases. I'm not naming any particular IC, but I am aware of instances where you have ICs that go after trustees to file complaints against each other. And I think that's a great conflict of interest, because in fact, they are drumming up work for themselves, right? So I'd like to see that explicit in the policy as a grounds for termination. Now on 4.0, when you spoke, the heading is application and scope. And then it goes on and says, this code of conduct applies to all trustees and members of the PDSB audit committee. So I was just wondering, why is it only audit and not our other committees? Thank you.
Thank you for that question. That's a great observation. The audit committee is the only one that's legislated to be covered by the trustee code of conduct. The other committees, it does not cover parent members, for example, on PIC, or parent members or community members on SEAC. It only applies to the audit committee. And the reason is because the audit committee is a legislated, statutorily required committee that confers the obligations of a trustee onto those members so that they have that kind of authority but remain independent. So they're like third parties, but they have to have the same decision-making authority as a trustee has. The other committees are all just, I shouldn't say just, that their authority is limited to making recommendations or providing advice, but the audit committee actually makes decisions. So because they are a deciding body without having to go back to the full board, they're to be bound by the trustee code of conduct.
Okay, thank you for that. I appreciate that. And under 6.8, when you speak about a trustee shall not advance allegation, I'm like, how would you protect? I kind of mentioned that actually. I just wanted to say in 6.8, I think it's really important to protect against this. because you could have situations where your IC is in cahoots with trustees and they target in specific individuals. So I think there has to be really explicitly addressed. And on the 6.36, where use of board property, service, and other resources. So when, if you have trustees, for example, when you say a trustee cannot use staff members' services, is that only you're talking about just election time, or is that can trustees, so if you're a trustee, can you be using staff in your own personal business, or so you're not, so that's a violation of the code?
That is correct. Yeah, that is
Okay.
correct. The board resources are meant for board business only, so there's no use of any kind of resources. It would be a conflict of interest and contravention of the code to use the printer or ask staff to do something that would further your personal interests or the personal interests of your family.
Mm-hmm. No, but I'm talking about the staff, the person itself. Like, can a staff say volunteer to help you run your business? Is that a violation of the code?
It would be a violation of the code if that staff person was coerced or they were improperly influenced and felt that they couldn't say no. That would be a violation of the code. It's also would be a violation of the code if that staff person was doing any of that work using any of the board resources, which includes time or assets. So they couldn't volunteer to do something for your personal business when it was a regular working hour for them.
Oh, okay. And what about, like, say, storing items? Like, if you have your business, are you allowed to store your items? So you can't use the facility at all. Okay, thank you. And then 6.38. Oh, no. That was a comment from Trustee Brad McDonald. Sorry, just bear with me. And okay, so under, I forgot what the title of this one was, but 6.4. So if you under the, like, how far back can you go with the code? So if, let's say, something happened 6 years ago, can you then come forward with that complaint, like 6 years ago? Because it mentioned that, sorry, I forgot to highlight it, but I just had on my notes, so I can't read exactly what was said. So I was just wondering if it means that, you know, somebody can say, oh, 6 years ago you did this, I want to bring it up for code now.
The code is meant to be effective during the term when you're acting as the trustee or your service as a trustee. Now that has a couple of factors to it, including any evidence of whatever happened 6 years ago would be extremely difficult for an IC to try to investigate and pursue. So it is meant to be more of a current document to be used with current behaviors.
Okay, thank you for that. And you mentioned about anonymous complaints will not be accepted or investigated by the Integrity Commissioner. And then further on, you mentioned in 7.4A bullet 1 about protecting the identity of any witnesses. So you could have an anonymous witness that can be saying things about you, but you have, how would, let's say somebody has a complaint about you as a trustee and they're anonymous because they say they're a witness. How can you respond if you don't know who this person is? So you could have something in context and say, hey, that didn't happen, or how would that work?
Just for clarity, when we have a complaint come in, the complaint cannot itself be from an anonymous provider. If there's an anonymous complaint, it's filed. it is not pursued because there's no way to really, as you say, question or contact or be able to pursue and give ample opportunity for all involved to say their perspective on the situation. However, once the complaint is placed with the Integrity Commissioner, what you're referring to in section 7.4A1 there is that the Integrity Commissioner will know who the witnesses are, etc. And that will form part of their investigation, but they're not required to provide you with the names. If it's a complaint against a trustee, they're not required to provide the names of the witnesses to actually protect the witnesses from retribution or bullying or anything, but the information will be available in the report so that the person that has an alleged complaint against them will be able to respond to the evidence and statements that were provided in the report.
Okay. So the witnesses can be anonymous.
Yes, the anonymous to the person against whom the complaint is lodged. Yes, but the Integrity Commissioner will obviously know who they are.
Okay, but how would you prevent if somebody wants to say make up something or just get back at you because they know, oh, I'm protected, but I can make your life miserable?
Because it's going through the Integrity Commissioner. They aren't doing this directly to the accused. It is all managed through the Integrity Commissioner.
Okay.
The investigation is done by the Integrity Commissioner, not the person against whom the complaint is lodged.
Okay. And sorry, I skipped over a question in 7.3, 7.3E, when you speak about governance services will select an independent outside investigator to conduct the inquiry. And that's talking about if the Integrity Commissioner, let's say, has a conflict or would be biased, right? How and who? So first, the who is going to find that independent outside investigator, and what process is used to select an independent, because I want, like, how independent is independent, like to ensure that, let's say, if it's the director of education, it's not the director's friend, or because they may have a stake in, getting this trustee kicked out, let's say. So how do you know that this independent person is truly independent?
Thank you for that question. It is a good question as far as trying to determine independence. There is the conflict of interest requirements with any kind of procurement or hiring. It's a bit like how long is a piece of string, because trying to determine in advance whether someone's got a predisposition, what we can do is ask about the conflict of interest in the predisposition. But I'm not sure there could be a procedure, and that's a very good point about making sure that there's a procedure for picking the independent inquiry. So I've made note of that, and we can do a procedure for that.
Yes, thank you. Because I don't think, say, it should be one person that goes out and says, I want this person to investigate, because I've known of instances where, for example, it's a friend of the person, so they may be independent, like not attached to the board, but they may be a friend of somebody at the board.
But that creates a conflict that needs to be declared, and that would influence whether they were hired or not. That is what conflict of interest means. So we'd have to, we can put in a procedure that says that the governance services would ensure that there is a conflict of interest check done, and then whoever is hired through the process would have to comply with the procedure.
Okay.
I'm not sure if I'm answering that correctly, but that's how conflicts of interest work.
Yeah. So I just think it's important to make sure we have some kind of process to ensure that the person, that independent person, is truly independent. Yeah.
I can work on a procedure for that, for sure.
Oh, thank you. And I say that not to be facetious, but I know people have after said, in different investigations, or like they were being coerced, that they'd say something and they're being coerced, and later they find out that, oh, this is somebody's buddy from down the road, right? So I think it's really important, because sometimes in education, there's such a big network, but it's really small sometimes. And I think, it's important to make sure that the processes for these investigators are truly transparent, and we make sure that the conflict of interest is one thing to declare a conflict of interest, but I think it's also important to have like solid checks and balances to ensure that we minimize those type of things. Now,
I would suggest that education is no different than any other businesses in that regard.
Yeah, that's true. Yeah. And on the 7.6 HI, 7.6I, so the trustee who is alleged to have breached the code of conduct may be present, but they cannot vote on it, which is fine. But can that trustee ask to have the vote recorded? Or somebody else has to ask? You can't participate at all, so somebody else has to ask. Okay.
Correct. Somebody else has to ask for it to be recorded.
Okay. And this is just in point G, the spacing is a little strange. So it's like huge spacing. So that's just neither here nor there, but it's
Thank you.
Yeah. And I think that was all my questions. Sorry, I didn't have time to get my sticky notes, so sorry about that. I'm just flipping through the paper. Yeah. So that's it. Thank you so much, Catherine.
Thank
I
you.
really appreciate that.
Thank you for the comments. Thanks to all members who provided comments. I really appreciate that. And again, as I say, happy to receive further comments. All trustees did receive the package with the trustee code of conduct in it. So, happy to hear any comments from any of the trustees before the October meeting.
Okay, perfect. So I could ask Trustee Green. I didn't realize he could unmute. So I'd just like to ask Trustee Green, because I haven't asked him to put something. You put it on the floor, please.
Yes.
Yeah, thank you for that. And Trustee Andrews, would you second it?
Yes, I will.
Great, thank you very much. So there are no trustee motions for consideration and no trustee notices of motion. So we have come to the end of the road. So I'd like to adjourn the meeting. Thank you. Oh, I thought we were just cut off a while ago. So could I have someone adjourn the meeting, please? Well, today, put it on the floor.
I will.
Yeah, thank you, Trustee Andrews. So good night, everybody, and thank you for your input. And as always, thank you to the staff and Catherine, you and your team. As always, I enjoy listening to your reports. Thank you.
Thank you very much, and thank you for stepping in as chair in Trustee Marshall's absence. So thank you for that, and thanks to all for attending.
Yeah, thank you. Good night, everyone. Bye.